What's up, ladies and gentlemen? It's the Resistance. Back at y'all with part 2, the continuation of Providence, Rhode Island trial. Part 2 of the Providence, Rhode Island trial. What we got coming up next, ladies and gentlemen, is the prosecution closing arguments and the decision. Appreciate all of y'all that's in here. Shout out to Jonathan Nicola, Social Justice, Rhonda, James Williams. Now make sure y'all hit the like, share, and subscribe button. Like I said, this is part 2. We about to get it in. Are y'all ready? Let's go.
I'm just a picture in the frame. Pause. I paint word pictures on the canvas of life.
I'm everywhere in public.
Once again, I want to give a shout out to everybody in the chat. I'm not going to take too much time with starting this. I just want to thank y'all for this 2.5 years of y'all support, riding with me and, helping me to be steadfast with following up on these cases and being steadfast with not budging or, falling over, getting these prosecuting attorneys and public defenders to get me to take a deal, because that's just not me, you know what I'm saying? But
what's up, Unicorn here?
Without any more wait,
but I'm starting to feel like the only one.
Without any more wait, we're going to get into this continuation of the audio trial here in Providence, Rhode Island. Right here on your left side of the screen, this is the arresting officer, Flavio Tavares. And we're about to start with prosecution's closing arguments. The last we heard on the last video was my public defender defense closing arguments.
All right. District Court is back in session. Please be seated.
Thank you. And Ms. Pearson, whenever you're ready. Your Honor, the night of October 21st of 2020 was a night of protesting that turned into something else. The officer Tavares testified that rocks, bottles, stone, debris, flares, and fireworks were thrown at police that night. And the city would suggest that that is not a peaceful protest, but rather a riot. The definition of riot is a violent public disorderly, specifically a tumultuous disturbance of the public peace by 3 or more persons assembled and acting together with common intent. Officer Tavares testified regarding the police dealt with that night, slashed tires, disabled police vehicles, an injured officer, and that he encountered this defendant, John McCullough, who he identified in court. When he got to, I believe he testified that he interacted with him and walked from Route 10 to Bissell at the intersection. And I'd asked the court take the context and the attending circumstances of the night of October 21st, 2020 into consideration. As we saw in the video provided by the defendant, this defendant was told to disperse by the Providence police multiple times. He dispersed from their immediate vicinity to the nearest sidewalk, where he continued to yell at police, using profanity for approximately 14 or 15 minutes. He neglected to disperse the area, and Officer Tavares testified that he had observed this large man of large size with a backpack. Couldn't tell if he had something in his hands, and that there was a crowd gathered.
You notice they said man of large size with a backpack. She also said that I was dispersed. The crowd was dispersed. No, she said the crowd was dispersed, and when I was asked to leave, I refused to leave. But what you got to understand is that them asking me to leave isn't a lawful order.
And that the officer's testimony was that he was concerned for his safety and the safety of others, because they had just dispersed the crowd. They had several disabled vehicles, and he did not want this activity to start again. In fact, on the video, the defendant, just prior to his arrest, he asks to be arrested.
So basically what they're trying to do is control the public speech. She just said that he was keeping it from not happening again. And basically, what is a protest? A protest is a form of speech. So because I was out there cursing them out, he didn't want another protest to form again. But he actually was trying to say that there was a crowd gathering behind me and I was inciting. And he didn't want that to happen.
I would also like to point out that the city was put in a position where it was not provided the discovery by the defendant, which the defendant indicates is exonerating, was not provided that, or even did not even know it existed. The city had heard about it from its police officer, which there was testimony about, but the video had been removed from the internet, so the city was not able to get access to that. The city was not provided that video until during the trial, during cross-examination of the city witness. And the city was not in a position to talk to that witness about the video because it was on cross-examination when the court deliberated. So any argument that the city's been sitting on evidence is moot. The city is happy to review any potentially exonerating evidence at any time.
I apologize about the volume, ladies and gentlemen. I did my best to try to expand the volume, to increase the volume. I mean, this was a very, very poor CD that was put together for me. It came from my public defender, but you know, it's just sometimes in courtrooms you can't help the volume. So I apologize about that.
Officer Tavares testified that this defendant was arrested because he was concerned for his safety and the safety of the other officers. And I would argue that this behavior by the defendant, yelling, swearing at police, threatening lawsuits, was ignored for 10 plus minutes. And the standard under the disorderly conduct statute is, subsection 3 is a person who directs at another person in a public place offensive words which are likely to provoke a violent reaction on the part of the average person so addressed. The city would suggest that this.
So they're saying that the words that I was using was pretty much enough to cause violence. The things that I said was they're pieces of shits. They're going to get notified about this. They don't like transparency. Officer Tavares tried to say that the things that I said that night was aim at their heads, field nigger, Uncle Tom officers, and maybe two other things, I believe. Those were the things that he entered in testimony. And my public defender, Andrew Francisco, had to play the whole tape back, and he had to retract those statements.
These words are alarming due to the surrounding circumstances, the fact that there had been a riot that night, officers injured, police cars damaged, a very large crowd dispersed. And I'd also like to point out that this event took place at 11 p.m. It's close to midnight, and this defendant is yelling profanities on the sidewalk for 14 plus minutes. And taking into consideration the average person so addressed.
And see, what prosecution fails to mention is that I was yelling obscenities for 14 plus minutes because I was threatened to be arrested for something that I was doing. I was recording that's protected under the Constitution. She didn't say that part. She said that I was just out there for 14 plus minutes yelling and cursing as if I didn't have a purpose. My purpose was to redress my grievance with those officers right there on that scene, especially Sergeant Papadopoulos, who initially approached me and threatened to arrest me. That was my purpose right there, and that's protected under the First Amendment. Let's continue.
In this situation, that average person is police officers, and Officer Tavares testified. He was concerned for his safety and the safety of the other officers. Based on that testimony, I would suggest that the city has met its burden and request that the court find this defendant guilty of this sort of conduct.
Thank you, Ms. Pearson. So in light of all of that, I think it's important for the court to review, the video and actually also the body cam video one more time. I did have trouble with the body cam video, so maybe if that could be resent to me with the password, I'd appreciate that. I do obviously have this video. I did not watch it ahead of time because it was only in for ID purposes only. Ms. Pearson?
Yes, Judge, I can resend the body cam video. It's usually through an evidence.com.
Yes.
But I can't give you a password because each person has their own username or password.
Right, and that would be fine. I know there was something recently to another panel where that had been done, which I was able to view, and it was very helpful. But I think in all fairness, I need to do that. I think there are important points being made in all of this that deserves that deliberation, frankly. So I would expect that I'll be able to do this in short order. The question is when it would be convenient for all of you to come back one more time for that decision. Today is Thursday, it's the 2nd. I could ostensibly, I'm trying to think of the timing, do this tomorrow afternoon, or Wednesday, Thursday, I know the dates, the next dates that Ms. Pearson is available. I could certainly, either one of those dates, work that in as a priority, whatever time during the course of the calendar, in order to deliver that verdict.
I am here next Wednesday and Thursday. I just will be a little bit late on Wednesday, but I should be here by 11:15 or 11:30.
Okay, all right, that's Wednesday. Okay.
Yes.
And Mr. Francisco, I know your calendar is a little different right now as well, since you're not here full time, but what is your availability this time?
Your Honor, Wednesday or Thursday next week is fine for me, if I could just consult with Mr. McCullough.
Absolutely, that was my next question.
Your Honor, Mr. McCullough he's a single father, and there's a potential issue with, I'm assuming with childcare, of just consulting the calendar.
Absolutely.
Up next is the decision, ladies and gentlemen. This is only a few more minutes longer, and then we're going straight into the decision from the judge. I want y'all to pay attention to this.
Your Honor, Mr. McCullough is available on the 8th.
What I believe is a biased judge.
The 8th on Wednesday. All right, so why don't we, Ms. Pearson coming in at 11. I know we have something else that we're hopefully going to be completing at noon, but why don't we, is noon time workable? I could do noon, or we could do it at 2. What would be preferable?
Noon, Your Honor, for the defense.
Noon, okay, so noon it is. So, all right, so reassign then to 9/8 at noon time for decision. All right, thank you all very much. And we'll see you all then.
All right, so coming up next is the decision. Make sure y'all hit the like, share, and subscribe, and notification bell as well, because this channel is shadow banned. They don't want the truth out there. And this, ladies and gentlemen, what more is the truth than an audio trial hearing of a case that I was arrested on? Now, this one was just for one charge, disorderly conduct. Okay? What I did was I redressed my grievances with the officers, and I used my First Amendment to the fullest. Okay? And I was out there in public, and they arrested me for that. So I had to tell them that I wasn't going to budge, and I was taking it all the way to trial. Now, in Rhode Island, you get an option to have a jury trial only if you get found guilty during the bench trial. So you get a bench trial whether you like it or not from the beginning. And this is what this was. Now, if I would have lost, I would have had the option to select the jury trial. But that judge knew. She knew she had to act accordingly with the law.
Actually, we're gonna have Mr. McCullough sit down at
this is like a whole
the table. So that's all right. I just feel like I keep playing games with you today. What's she doing now?
Laughing and joking, yucking it up, talking about they playing games. No, who they was playing games with was me. They was playing in my face the whole time, all the way up from the point where Officer Tavares arrested me, all the way up until when I was found now not guilty. They played in my face the whole time. But when they play in your face, you just sit there, you stay still, and you just look at the judge, and you tell them that you're not taking no deals and you're going all the way to trial.
No, I'm doing actually a decision, and then I know Ms. Adams is.
I just need to read.
Okay, all right. Yeah, okay, thank you. All right. So we're back on the record in the matter of the City of Providence versus John McCullough, case number 6120-08966. There's one count charged in this complaint, is that of disorderly conduct allegedly happening on October 21st of 2020. I think that this is a bench trial. I did not write out an entire decision on this, so you'll have to bear with me as I work my way through why I'm doing what I'm doing here. Essentially, I did take a look at all of the evidence. Again, there was a video by defense, there was the body camera video, there were some documents, photos, etc. that had been submitted. Reviewed everything as part of this. I also spent some time going through the case law regarding disorderly conduct and weighing all of that and trying to make a determination here of what was appropriate. This statute, as it was cited in the complaint 1145-1, there was no specific subsection that was given on this. So I'm just going to grab this and just indicate specifically for the record what that said, and I'm going to do that so you can hear me. All right, so disorderly conduct 1145-1A is a person commits disorderly conduct if he or she intentionally, knowingly, or recklessly, number one, engages in fighting or threatening or in violent or tumultuous behavior, which I don't think is appropriate here. Count number two, subsection 2 is in a public place or near a private residence that he or she has no right to occupy, disturbs another person by making loud and unreasonable noise, which under the circumstances would disturb a person of average sensibilities. I don't necessarily think that that is appropriate or applicable in the circumstance either. And then subsection 3 directs at another person in a public place offensive words which are likely to provoke a violent reaction on the part of the average person. So the average person. Okay, now there's no delineation about maybe not the average person, but police officers, not the average person, but firefighters. We don't consider that actually in the case law here in Rhode Island. We don't make a distinction regarding that. So, all right. So what that leaves us with then basically is analysis that falls under that fighting words. Section of disorderly conduct, and there was a lot of discussion about that during the closing arguments. And as with any First Amendment constitutional right, we say this because I think we all think of it, or the public at large thinks of it as just being, it's a hard and fast rule. Whatever's in the Constitution is a hard and fast rule. But there's always been developments in the law over time where there are exceptions or there are certain types of analysis that have been basically put into law by the Supreme Court in approaching this. So there's always some exceptions to the rule. So the question is, okay, so where does this fall under our case law and whether or not Mr. McCullough's particular actions are enough to constitute disorderly conduct under that subsection. Couple of things. So when Officer Tavares testified, he indicated that he was worried that Mr. McCullough's actions were going to incite others. He was concerned that things would escalate. He thought a threat was imminent. This is basically testimony that he had given. This came upon the heels of a protest, which the Providence police were called to the scene where Cranston was already there. It was right on the city line. So Officer Tavares had reported to the scene. I think it was early evening. He was part of a particular force that was there to deal with protests or riots or whatever might come about, and however you want to label it, such as what was happening there. And so their job was to apparently disperse the crowds, because there was bottle throwing and debris flying around, and patrol cars were damaged during that time, and eventually all of that seemed to be dispersed. There were motorcycles, and anyway, it was essentially a mess. That had been dispersed, and Mr. McCullough is not being charged with anything that results as part of that particular situation. This allegedly occurred a little bit after that, when the police were sort of doing a lot of mop-up. And Officer Tavares said that he was actually still on scene with some of the other officers because they were doing what he called roll call, which is really kind of assessing where things stood, what the other arrests might have been, but they were waiting for the tow trucks for the police cars that had been damaged. And on the video that Mr. McCullough took, you certainly can see them gathered near the police cars. So there had been a little bit of passage of time, and I'm going to get into that a little bit more in just a moment. That's essentially this context in which this arose. Officer Tavares said that basically that due to the circumstances of that entire evening, he was concerned for their safety. You can't take words lightly given the context of what had been happening. It was alarming given the circumstances, and the individual needed to be removed from the scene. He also indicated that they were trying to pay him no mind, which is pretty much what's reflected in the video too that Mr. McCullough took. I mean, there was a lot of just sort of watching them not interact except with each other. As far as what allegedly happened regarding Mr. McCullough's behavior, Officer Tavares did say that he was essentially aggressive in his words, that he wouldn't disperse, that he indicated that he had made some specific comments, not the first one where he said somebody said aim at their heads. He couldn't really attribute that to anybody in particular, but that's what he turned around and then saw Mr. McCullough in that area. There were some people who gathered around there. You can see it on the video. Can't really tell how many. Officer Tavares was concerned that there were some people who were living in the area who came down off the porches. And certainly there were some individuals there that Mr. McCullough was talking about things that had been happening in the city, let's say, last summer and fall, etc. I will say that in watching the video that Mr. McCullough had made, I'm just going to note what some of those comments were.
So she's about to repeat what was already said by prosecution and defense, the words that I said that night. I don't understand what the point was of her saying the things that I said after she ruled in my favor. But she decided to repeat the words that I said, I guess to clarify, maybe to clarify that, you know, I was in a First Amendment standing with what I was doing.
Okay, so there was, I think from watching Mr. McCullough or listening to Mr. McCullough, because we couldn't see Mr. McCullough because you were videotaping, so most of the comments that were being made were I think, provocative, pushing the envelope, as we say, trying to get to the police.
She said provocative, pushing the envelope, and trying to get to police. So just totally ignoring the unlawful command that was given to me. And if I didn't abide by what they said, that I would be arrested. Now, I really think I got something on this judge. You know, a lot of people was talking about, you know, has this made it to the feds yet? Well, no, it hasn't. You guys already seen that I have one case that's in federal court. I don't want to bunch my things up together. I don't want to bunch too many things up together. I'd rather just, you know, move accordingly. That doesn't mean I'll wait beyond the 2-year limit. Even that's a state local law. But district courts, circuit courts, they refer, if it's not clearly established, then they refer to the lower courts on, you know, time limits. So that argument would get by if I waited over 2 years. So let's just say I still got another year to put this in. But I got one case in the federal court system already. So I'm going to let that play out. And then I'll work on this one right on down south in Rhode Island.
Really was a provocation in the statements that were being made. If you want to get specific, I mean, there were some things that were...
And I mean south of Massachusetts. South of Massachusetts, not down south. Not past the Mason-Dixon line. South of Boston, Massachusetts.
One would consider them to be vulgar, upsetting. You guys hate transparency.
you're a piece of shit, you're all pieces of shit, you're cold-blooded pieces of shit.
She got it right too. She got it down right on how to say it too. She said it just like me, but I'm trying to figure out why she repeating it for what. And she's trying to reinforce that I'm within a First Amendment standing, that what I'm saying is protected under the Constitution. But she did mention I was pushing the envelope, provocative, and trying to get to the police. Once again, I was stationary on that corner, didn't move one time. The only thing that moved was my mouth, exercising my First Amendment to the fullest.
Tonight, he threatened to lock me up because there was brief exchanges. One of the officers was walking away.
Wow, brief exchange. What she did was she chose to call that a brief exchange, the part with Papadopoulos. Okay, this is what she called a brief exchange.
120, you gotta clear out of here. All right, we just dispersed everybody. You need to leave too. All right.
So it's a crap. I could walk this whole street.
This is what she's calling a brief exchange. This woman right here just told me not to walk the public street in this immediate area right here. And I told her I can do that. And then once Sergeant Papadopoulos approached me, this is when the judge said it was a brief exchange.
Pushing the envelope, as we say. You're a piece of shit, you're all pieces of shit, you're cold-blooded pieces of shit. How many heads did you crack tonight? He threatened to lock me up because there was brief exchanges. One of the officers was walking away.
Let's check out that brief exchange.
All right, so what's the problem? All right, well, don't tell me to do nothing. Yeah, I busted the window over there.
120, you gotta clear out of here. All right, we just dispersed everybody. You need to leave too. All right, we're not doing this. Stop walking.
There's no paper.
Stop walking. You're gonna get arrested. You've been notified once.
Really?
All right,
Okay.
take off. I'm done with you. Get out of here.
Mm-hmm.
You come back, you're getting arrested.
On the public street? On the public street?
You've been notified.
On the public street, I'm gonna get arrested?
It's crime scene. Have a nice night.
I don't see no tape.
We're about to put it up. Don't worry.
Hey, LT. Hey, LT.
That's what they called the brief. That's what this judge called a brief exchange. And, she went into her explanation of this case so deep that I don't think that she realized how biased she was. And I think I might got something there. I'm just putting it out there.
From him, all of those types of things. But essentially really kind of taunting the police and trying to get some reaction to them.
Taunting the police and trying to get some reaction from them after this, in the judge's words, brief exchange.
Yeah, I busted the window over there.
120, you gotta clear out of here. All right, we just dispersed everybody. You need to leave too. All right, we're not doing this. Stop walking.
There's no paper.
Stop walking. You're gonna get arrested. You've been notified once.
Really?
All right,
Okay.
take off. I'm done with you. Get out of here.
Mm-hmm.
You come back, you're getting arrested.
On the public street? On the public street?
You've been notified.
On the public street, I'm gonna get arrested?
It's crime scene. Have a nice night.
So she just totally ignored the fact that I was threatened with arrest, and she just jumps to me being provoked. This is what they do. This is what they do. This is how they portray the press, the private press, the everyday cameraman that's on the street recording these pieces of shits during the course of their duty. This is how they portray people like me. Okay? It's no way around it. They're always going to do it, but you got to stand firm and you got to stay steadfast in what you're doing and take it all the way to the end. They say that the biggest way to make a motherfucker look like a fool, just let him talk. Just let him talk.
Yelling, am I good right here, LT? Can I stand here? But just a kind of a continual barrage of statements by Mr. McCullough. All right, so does that constitute disorderly conduct under our law? That's the big question. And after
She mad right now. She don't want to rule this the right way, but she got to rule it the right way because she know what I do. Oh, she ain't just go back and this is about 4 days later. I had to travel to Rhode Island about 3 or 4 times just to get the decision. But she didn't just research the body cam and the video. Oh no, she figured out who the fuck I was too. And she know that she don't want the upper courts to be dragging her ass back into this shit.
I'll get right to the chase on this. I don't believe it does constitute disorderly conduct under our case law. There have been a number of decisions, and certainly Mr. Fernandez raised some of them, but in Rhode Island, because every state has a little bit of a different spin on this, but all of the states, Rhode Island included, it really comes from whatever the U.S. Supreme Court had put in place regarding some of these things. So the case that we always hear about is that of Tavarossi. So if you've ever deal with any of these cases, disorderly conduct cases, et cetera, all you need to say is Tavarossi, and everybody knows what you're talking about. So, but after Tavarossi in Rhode Island, there were some other cases that were generated that really looked at some bits and pieces of that. So, I just want to touch upon that. One of the cases that was fairly recent was 2015 was the Matthews case, and that was actually something that Mr. Fernandez had found as well. And if I can find that, I can give you the site, although that was given at the time. It is 111 Atlantic Reporters 3rd, and it's at page 390, essentially. 391. All right, so just to go through that a little bit. Offensive words really can be looked at in a few different ways. Are they likely to provoke a violent reaction on the part of the average person so addressed? So we're back to that again. I'm not saying, again, that offensive words, well, the police should be have a thicker skin about that. We talk about that a lot, but actually when you look at the actual case, it actually says we don't make that decision. And so it's always going to be the average person going to have a reaction to this reaction to these things that are going on. And as I mentioned before with the Constitution, and there's always analysis that gets generated, there is an analysis team. We're not going to take those words or actions into a context. Everything is all about the circumstances around the situation. And so cut both ways in this particular case. So essentially, one of the cases that was cited was McKenna, and McKenna had to do with with a city ordinance. It wasn't the disorderly conduct statute, but it was talking about the same type of thing, the same
THES Galaxy S10 disconnected.
Language within that did carry through to Matthews and some of the other cases. So I just wanted to review a little bit of that because I thought it was pertinent in processing all of this. McKenna was at 415A 2nd 729. It was a 1980 case. The situation here in McKenna, very different kinds of actions, et cetera, et cetera. But one of the findings, as you said, is with respect to the claim that her words were fighting words, it's true that the defendant's words were abusive to the policeman as a group. but we cannot say on the facts presented that her words created an inherent likelihood of provoking an imminent retaliation. She addressed her remarks to a group of 5 men. She spoke to them as a group, not individually, not face to face. She was about 15 feet away when she did it. The remarks did not concern the officers individually. And essentially, to us, this suggested they were more annoyed with her than moved to violent retaliation. State may not punish the use of words that merely elicit indignation, disgust, or anger from the addressee. In this particular case, the police were arresting some juveniles, and Miss McKenna was kind of an observer of all of this. Okay? She wasn't directly involved in all of this, and so she was standing a little ways away, and she was saying some pretty graphic and obnoxious things to the police. So that was the kind of situation. We said, not under the circumstances, it doesn't reach that point where it really constitutes fighting words under that particular ordinance. Tavarossi, I'm not going to talk about at this point. I don't think we need to, because we all know where we stand on that pretty much. With Matthews, a little more interesting. They talk in Matthews, Justice Robinson does talk about McKenna and basically making some of those same observations. He indicates we have conformed our definition of fighting words to comport with the evolving United States Supreme Court precedent, acknowledging that such speech, in order to fall beyond the pale of the First Amendment protection, must have a direct tendency to cause acts of violence by the person to whom individually the remark is addressed. That's citing a U.S. Supreme Court case. One of the things, though, is that one of the sort of exceptions in trying to figure out whether or not something is going to be protected under the First Amendment, protected under the case law here in Rhode Island or not, is that you have to look at the context. So that's the difference, okay? They say you've got to look at the circumstances. You've got to take that into consideration. For instance, he says, page 400, in addition, this court acknowledged the admonition of the United States Supreme Court that, quote, fighting words are recognized as having some social value and are not to be punished on a per se basis, but only when their use results in the likelihood of an imminent disturbance. In other words, the context, italicized, in which the words are uttered must also be the focus of our analysis. So in this particular situation, I had to really look at what context was here. The city had said, and I know that Officer Tavares had said, that the context here was that this situation arose in conjunction with a protest / riot, again, depending on what your definition is of what happened, that had been taking place. And there had been an officer that had been injured, I think the Cranston officer, they thought. The patrol cars were damaged, debris was being thrown all over the place, particularly to police officers. But there was this gap in time. Things had settled down. This was a different section of the roadway area than where the actual protest / riot had been taking place. People had predominantly dispersed. Officer Tavares's reaction, understandably so, was that this behavior by Mr. McCullough, not dispersing, standing there, continuing to taunt, say the words that he was saying, some people gathering around, was going to heat up and result in the same situation kind of scenario as they had just been dealing with. However, that being the case, I do think that there was a difference here. And I think that, again, there was a difference in time. Mr. McCullough was not on top of the police officers. He was some distance away from them and was making a point of saying, you know, basically he was in a public area. You know, am I good over here? You know, I'm okay over here, right? But he was at a distance from everybody. He wasn't individually addressing the officers. He wasn't in their face. There had been, I think it was actually Matthews where that incident had taken place where it was directly directed to a couple of troopers. They were near each other. It was in the context of that investigation was on an individual. This was something where Mr. McCullough was not part of that overall part or seen as a component of that underlying riot, confrontation, protest. This was after, and he was sort of not joining on, but this was kind of a follow-through. He was not the focus of the investigation. He was not the focus of why the police were there in the first time. That is exactly what the case law is talking about when they look at context. It's exactly those factors that they're looking at. So because of that, I am hard pressed to make a finding that Mr. McCullough's words, more than his actions certainly, but it was mostly the words, crossed the line and constituted disorderly conduct under our case law and the statute. That being said,
I gotta take that back again. She said that my words constituted disorderly conduct.
Mr. McCullough, you got what you wanted. You were arrested. You were broken away. Mr. McCullough's words, more than his actions certainly, but it was mostly the words, crossed the line and constituted disorderly conduct.
My words crossed the line and constituted disorderly conduct.
Under our case law and the statute. That being said, Mr. McCullough, you got what you wanted.
I got what I wanted.
You were arrested.
I was arrested.
You were poking away at them. You just continued to do, it was a provocation.
It was provocation.
As the court had said in one of these other cases, the reaction was justifiable, but it was not considered to be illegal.
The action was justifiable, but it was not considered to be illegal, is what I thought I heard.
Mr. McCullough's words, more than his actions certainly, but it was mostly the words, crossed the line and constituted disorderly conduct under our case law and the statute. That being said, Mr. McCullough, you got what you wanted. You were arrested. You were poking away at them. You just continued to do, it was a provocation. As the court had said in one of these other cases, the reaction was justifiable, but it was not considered to be illegal.
So, you know, she patted the prosecution and the police officer's ass as long as she could, but she quoted from a previous case that the actions of the police officer was justifiable because of my words, but what I was doing was not illegal.
You just continued to do, it was a provocation. As the court had said in one of these other cases, the reaction was justifiable, but it was not considered to be illegal. It wasn't disorderly conduct on a legal basis, it was provocation. And there was a response.
So it was provocation because I was threatened to be arrested if I came back to the scene right here across the street. If I came anywhere back over there, I was going to get arrested. But because I was redressing my grievances with those same police, it was provocation. And that's coming from the judge.
To it, right or wrong, but it was something you essentially had opened an invitation to. So they did it. They arrested you. So, but you're not guilty of disorderly conduct. And that's it. Thank you.
So she said, I got what I wanted. They arrested me, but I'm not guilty for disorderly conduct. So she basically pretty much made me look like the bad guy, even though she found me not guilty. I'm looking for the judge's name right here. I'm in the docket sheet right now, and I'm looking for the judge's name because I forgot her name. I want to put that on record. And I can't find it. I apologize about that, y'all. I'm looking for the name of the judge. I would love to get her name on the record of this this live right here. And I'm not able to find it. I'm looking in the folder. I'm probably going to put that name up on a community post when I find it. I apologize about that. But yeah, that was the judge's decision right there. That was her decision. And she had to go in favor of the Constitution because she knew that I didn't commit a crime. But she patted the asses of the prosecution and she patted the ass of the police officer. Because judges protect the police officers. They protect them. Like I said, this is a digital manual on how to not fold when you get slapped with trumped up charges. Don't get scared when you read the buttermilk narrative that the police officer wrote on you. It's just what it is. It's a narrative. Okay? But it's also important to record your interactions with police as well, because without any kind of video, your ass is grass. So if you're in a tight situation, pull out your phone and record it. You never know, those 30, 45 seconds just might save your life. It's the resistance. If you want to see stuff that's real, come on over here. Hit the like, share, and subscribe button. Notification bell as well. Shout out to everybody in the chat. I appreciate y'all rocking with me. Rhonda, Misha Boo, Destiny Brown, Matt Bordsley, Mom's Wholesome Videos, David Avila, Breaking the Flow, Free Church Press, Truth Be Told Audits, Wake Up America and Resist. Wake Up America and Resist. Social Justice. John Denicola. Dwayne Kirkland. William Sharon. Right to Freedom Girl. Destiny Brown.
Are you listening?